Case number 111640, State of Kansas v. Ward.
Good morning, Mr. Chief Justice. If I may reserve 2 minutes for rebuttal.
2 minutes is granted.
Thank you. May it please the court, for purposes of a brief statement as to how we arrived here in this case, Mr. Christopher Ward was convicted at the district court level of 2 counts. 1, of making false information, and 2, theft by deception. Mr. Ward was in a business partnership with one other man. They did carpentry work and repair work around Johnson County on homes and businesses. This business was failing, and it was failing fast. The partnership was running out of money, and they needed more funds. They had an outstanding contract to complete some work on a townhouse project, and they didn't have enough money for the materials and the labor to front for the project before they'd get paid. Mr. Ward and his business partner discussed their insolvency and realized they needed a quick infusion of cash. Mr. Ward told his partner, "I have an idea. I know a gentleman who I think will float us some funds." And his business partner told him, "That sounds good. See what you can do." Mr. Ward then approached Orrin Sweeney, another gentleman who was in the same field of work, who owned another business, Night and Day Remodeling. And when he approached Orrin Sweeney, he told Mr. Sweeney, "We need cash. What kind of terms can you offer?" And ACG Restoration, Orrin Sweeney's business, offered him $20,000 up front. And they signed a contract whereby Orrin Sweeney would then be paid later with the proceeds of the project.
Excuse me, Mr. Gonteski, ACG was Mr. Ward's business, right? Not Sweeney's business. Sweeney was 9 Day, right?
Correct.
Okay,
correct.
I'm sorry. I think it was stated. Okay.
Thank you for the correction. Yes.
It's okay.
Mr. Ward's business was ACG Restoration. So Mr. Sweeney agreed to float the $20,000, and Mr. Sweeney wrote a check for $20,000 to Mr. Ward's business, his partnership, ACG Restoration. And he told Mr. Ward, this is a business-to-business deal. And in fact, the testimony at trial was, while they were negotiating this deal, Mr. Ward asked Mr. Sweeney specifically, "Could you please put or Chris Ward on the check? For purposes of negotiating it, it would help me." And Orrin Sweeney said, "No, I won't do that. This is a business-to-business deal, as our contract states. So I'm paying the $20,000 to your company, not to you personally."
And I have a quick question about the contract, the written document.
Yes.
It was an exhibit.
Yes.
Was there any testimony about when Mr. Rhodes signed that document?
No, there was not.
Okay, his signature appears.
Except that I can tell you it did not occur at the same time as when Mr. Sweeney and Mr. Ward negotiated
He
it.
wasn't present.
Correct.
But we don't know whether it was the same day or before the check got negotiated or any of that.
Correct.
Okay, thanks.
So then Mr. Ward took that check that was made out to ACG Restoration, and without the authority of Mr. Sweeney, he wrote his own name on the check. The testimony was essentially undisputed that Mr. Ward appended his own name to the payee line of the check. And if you look at the exhibit, you can even see as much. It's in a different handwriting. Mr. Ward testified and admitted as much in the trial. He then took that check to his own bank, First National Bank, and negotiated it, deposited it into his personal account, not the business account, and spent the proceeds rather rapidly, not on business-related expenses. He was charged with making false information for what he did with the check, and for theft by deception for stealing the funds from either ACG Restoration or from Bank of America. Bank of America was Orrin Sweeney's bank. That's where the check account was held. So that's what the trial, that's the evidence that was presented at the trial. He was convicted on both counts. At the Court of Appeals, Mr. Ward argued that it was error for the state to charge him with false information. Rather, he should have been tried on a forgery count, and further that theft by deception, the elements were not all satisfied because the 2 listed victims were not deceived in this case.
Counsel,
Excuse me.
I had a factual question.
Yes.
Go ahead.
There was an order of restitution
There
in
was.
this case, and who was to receive the $20,000 in that order?
First National Bank was to receive those funds through the restitution order. They were the ones ultimately left holding the bag when the two banks negotiated out who was going to be left holding the bag for the $20,000.
But your complaint is that it was not First National Bank who was the victim of this crime, but Bank of America.
I need to prove Bank of America because that's that's the complaint language, and that was the language that was used in the jury instructions. So that is what I'm defending here. Bank of America was the account holder for the $20,000 of Orrin Sweeney's money. Bank of America did send those proceeds on to First National Bank when the transaction happened. It then unwound later when all the fraud was discovered. That the Court of Appeals took issue with that. What I would say in response to the fact that the restitution order lists First National, I don't believe that's dispositive in proving that Bank of America was never deceived. We often have someone other than the listed victim that ends up on a restitution order or that receives the payments from the clerk when restitution is ultimately paid.
Well, then
because
what evidence was produced at trial that Bank of America was deceived?
The evidence...
What you had no one testify from Bank of America, as I understand it.
That's correct. But what we did have was we have the check itself from Orrin Sweeney's account that showed Bank of America is where it was drawn from. And we also had testimony from First National that talked about how the payments are processed through their bank and how it was sent on to Bank of America for those proceeds to be remitted to First National.
So First National spoke of Bank of America's victimization in this case? Is that how the evidence was?
I don't know that they spoke of their...
Bank of America was the actual victim?
I don't know that they put it in so many words, but they did talk about how when the transaction was initially conducted before the fraud was discovered, the check was negotiated at First National Bank. First National Bank, through the usual course of business, then sent it on through Bank of America for them to receive the $20,000 from Orrin Sweeney's account. And our argument has always been Bank of America was deceived into giving up that $20,000 and sending it on to First National Bank, where they had an account for Christopher Ward, not for ACG Restoration.
How do you know if they're deceived if they don't testify that they were? I mean, we just...
I think
you just infer it?
I think you can infer it because presumably Bank of America would not have remitted those proceeds if that check had been written to ACG Restoration and First National Bank was asking Bank of America for those funds, but First National Bank did not have an ACG Restoration account. They had only a personal bank account for Christopher Ward.
In essence, it's circumstantial evidence of how banking's done.
Correct. And there was argument to that effect as well.
I understand.
I'm not only arguing it after trial.
Right. I have a couple other questions. First of all, though, I'd like to just kind of refocus on what the issues really are. You recited them as raised in the Court of Appeals. Okay. But what we have here really are two sufficiency of the evidence challenges.
Precisely.
Okay. So really, it doesn't matter whether he was guilty of forgery. What matters is whether you proved false information.
You just summarized a huge portion of...
Well, I like to cut to the chase.
And I appreciate that because that's exactly the way I view it as well.
I'm sorry.
No, go ahead. That's fine.
I mean, all of the history of how those two crimes have been differentiated correctly or incorrectly or whatever is all very interesting to law nerds like us, but it's not what this case is about. This case is about whether you prove false information.
Precisely.
Okay.
And I believe we did.
You didn't charge altering in any way, though. You charged making.
Correct.
How did he make this check? He didn't make this check. Mr. Sweeney made the check.
Mr. Sweeney wrote part of the check. He wrote the amount. He signed the check.
It's the signing of the check that is the making, isn't it?
Well, I think this making of a check can encompass more than just the signing on the face of the check or the endorsement on the back. Mr. Ward, we argued, made the check when he wrote a portion of what appeared on the face of the check that the banks then relied upon later when he remitted that for payment. I believe as though the sufficiency of the evidence is proven when you look at the false information elements. I believe every element was satisfied.
Well, let's talk about a second one. We talked about making, and you told me what you think. What's your legal support, first of all, for that assertion that altering the payee line, adding to the payee line is making?
I don't have a full definition here of making in front of me. but I believe as though making is not limited to simply signing the face of the check.
I may have overstated a bit on that. The whole check is being made, not just the signature line, but he didn't purport to be the party on whose account the funds were to be drawn, for
True.
example. Okay, and isn't that really the maker of a check, the person on whose account the money will be drawn?
I think it can be, but I don't believe as though it's limited to that.
Okay, but that's just your belief as you stand here today. You don't have anything to cite.
I don't.
Okay, that's question number one. The other element I want to talk about is falsehood. It was certainly being falsely represented that it was authorized, that he was an authorized payee, but his name wasn't false.
Correct.
I'm having a little trouble on that too.
The element of false information that when he made or delivered, generated, distributed that check, when he did so, he had knowledge that it falsely stated some material fact. And that material fact was that it's payable to
But
him.
he was a payee. Okay.
Correct.
All
So
right.
the falsehood is not his name, but his status.
Correct.
He
Status.
As a
falsely
recipient.
identified himself as having the status of a payee. That's the falsehood you're relying on.
Exactly. Solely.
When we have a term in the criminal law such as make or maker, and it relates, at least in the fact situation, to a transaction that's covered by the UCC, why can we not look to the UCC for how we would define maker under the UCC when we look at a check?
I think we can look to it sometimes for guidance, but I don't believe as though it should be determinative. When the legislature was writing the statutes, the criminal statutes, they didn't refer to the UCC in that criminal code. And likewise, when the UCC was adopted and crafted, it was not done so with the intent for it to be interpreted in a criminal context. I argued, and I do cite to a case from this court, 2013, when this court in Foster was reviewing a Court of Appeals opinion that had interpreted some UCC provisions in the context of a criminal case. And that's when this court had stated that the UCC is unique and specialized area of the law that is not easily transferable to other areas, including the criminal context. The criminal code has its own definitions. Even the criminal, 215111 is a definition section that has lengthy definitions for many terms, although not all of the terms utilized in this case or in any given case are defined there. So I think we can look to it sometimes for guidance, but I don't believe as though it should be determinative. Likewise, on the theft by deception count, when the Court of Appeals found the reasoning in the Court of Appeals opinion that reversed the theft by deception count was that Bank of America, they argued, could not have been deceived in this context because as the first receiver of the check, First National Bank was the bank that was the one that was ultimately forced to be left holding that bag. Bank of America, through UCC provisions, would never be held accountable for those funds. That's the response I have to that is that that's not an argument that was ever made to a jury. These UCC definitions and provisions were never argued to them. And while we're here on a sufficiency of the evidence argument, when the evidence is looked in the light most favorable to the state, I believe as though it shows that a reasonable jury could conclude that Mr. Ward both made a false statement on the front of that check, making the check before he delivered it to his bank, and likewise that Bank of America was ultimately deceived by that falsehood when that check went through the banking system and ultimately pulled the funds from Bank of America or in Sweeney's account. So while the UCC may be helpful and may be instructive at times, I don't believe as though the Court of Appeals rationale is justified here when they rest their reversal of the theft by deception count almost exclusively on a narrow UCC provision that talks about transfers between two banks when an account is held in one bank and the check is negotiated at another. Those were not arguments presented to a jury. Those were not arguments argued by any party at the district court level or even at the Court of Appeals level. Neither side ever argued those UCC provisions. They appeared in the Court of Appeals opinion.
Excuse me, Mr. Gonteski, I agree with you. Technically, they were never argued exactly as the Court of Appeals relied upon them, but in fact, the state did rely on the the general content of the UCC when it said that that Bank of America was deceived, for example. I mean, the reason Bank of America was deceived is because of the way the UCC works and the way checks get negotiated and the way warranties work between banks, et cetera. So, I mean, the state's sort of talking out both sides of its mouth on the UCC here. It may not have technically argued the UCC, but it in fact relied upon the UCC to prove victimhood by Bank of America. And before I finish, Bank of America was an alternative victim, right?
Correct.
ACG was the other victim,
Correct.
Okay, so the state's theory was that when he took possession of that check, ACG took possession of the check because he was a partner of that company.
Precisely.
Okay,
And it never ended up in their account.
right.
To the extent that the state does rely in some fashion on UCC provisions, to the extent that we relied upon any of those, they were simply in the context of what common knowledge and common understanding of how banking works would be utilized by a jury. We had the banker from First National Bank testify about those procedures. I recognize I'm out of time for this portion. So at this time, unless there's further questions.
A practical question. Why charge this as making a false information rather than forgery, since forgery appears to be pretty straightforward?
I believe as though a part of the rationale in charging it the way it was looking at the last decade of Court of Appeals opinions that preceded the charging in this case, in which there were cases very, very similar to this, where documents were falsified in a person's own name. The state, as the Court of Appeals recognized in their opinion, the state did rely upon many of those opinions that seemed to draw a line between forgery and false writing by stating false information was essentially a type of forgery wherein somebody is acting in their own capacity, in their own name, or for their own business affairs. I agree with the Court of Appeals that that language is not in the statute for false information, but in delineating the two, it's an extremely foggy delineation, it's hard to follow, and it's also one that the only other nugget I would add on that argument is that when that distinction was first being drawn by this court in the 90s, it was a significant distinction to draw, and it was important because the two had different severity levels. These two offenses no longer have different severity levels. If anything, Mr. Ward received a benefit by being convicted of false information rather than forgery, because while they're same severity levels, forgery has several special rules that aggregate, false information has none.
Any more questions? Thank you, counsel.
Thank you.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Christopher Ward. I'm going to take the issues as they are sort of presented, talk about theft first, and then making a false writing. In the first case, since this court's pronouncement in Finch with regard to theft by deception, it's clear that part of the state's responsibility when charging and proving a case of theft by deception is they have to show actual deception and actual reliance by the victim in the case. And I think Judge Powell got it exactly right in this case, that to the extent that Bank of America was a named victim in this case, there's no showing of actual deception or reliance. And my colleague talks a lot about and complains about the use of the UCC by the Court of Appeals in this case, but this case did in fact involve a negotiable instrument. And so it seems extremely appropriate for the court to have looked at the UCC and the operation of that with regard to this particular negotiable, a thing that happens to be a negotiable instrument, and the fact that Bank of America didn't rely on anything on that check. Bank of America relied on the warranty from First National Bank.
Well, more importantly, they didn't lose anything.
At the end, that's right. They didn't lose anything, but especially for the purposes of our argument, it's also the case that they weren't deceived.
They weren't going to lose anything, because if the check had gone through as made, it was an authorized signature and would have gone through normally. If it's altered, then they had recourse, and so they really had nothing to lose.
There's no reliance.
As long as the signature on the check was authorized out of that account.
That's right.
Is it a fair conclusion to say there's no reliance simply because there's a make-whole provision that Bank of America knows it can also rely on? In other words, I guess you put the question, would Bank of America have issued the funds had they known about the false information? Or
I mean, the question is, was there actual deception to Bank of America? And is there, well, really the question is there evidence of actual deception to Bank of America? And then is there evidence of actual reliance?
and why couldn't a jury reasonably conclude from the circumstantial evidence that there was?
It's just, I mean, there's no evidence of that. I mean, partially for the reasons that Justice Rosen talked about, and I think it is relevant, the fact that any representations were made by First National Bank regarding that check to Bank of America. That's I think what the Court of Appeals was saying in their opinion regarding that. That's the way that system works. That there is no evidence of actual reliance on the part of Bank of America with regard to the accuracy of that payee line.
What about ACG? Excuse me. You want to say something else about it?
Real quick here, the opposing counsel said that there was no account at First National Bank for the ACG, but the Sweeney's Bank would have no reason to know that. When First National Bank puts it in the system for collection, they don't say, oh, by the way, the money went into Chris Ward's account, not ACG. They just put it in for collection. And so there would have been no knowledge that it went to an unauthorized account on the part of the
Bank of America.
Bank of America.
I think that's right. Not being an expert on those things, but I mean, and so I'm relying on the evidence in this case. And there certainly is no evidence that Bank of America relied in any way to their detriment in this case.
Mr. Hodgkinson, the ACG was an alternative victim on the theft by deception. So where does the evidence fall short on the ACG?
Sure. Well, I mean, I think that's a difficult proposition for them to, first of all, even if only evidence is insufficient with regard to Bank of America, I think that's problematic because the jury was told they could rely on either, and I haven't really fleshed out whether there's an alternative means kind of thing there. But to take your question directly, again, there's no evidence that I mean, it's very difficult to suggest that Mr. Ward deceived himself. Even assuming everything, as I have to for this issue, in favor of my colleague, the evidence that he deceived himself. And there's certainly no evidence that Mr. Rhodes was deceived. Again, evidence taken in the light most favorable to the state was Rhodes didn't even know about this check or that this check had been negotiated. And so, you know,
He knew he was
who was deceived?
He knew he was supposed to get $20,000. I mean, he did sign the agreement, and the agreement is not much of an agreement, but it does have on the last page ACG 20K as a notation. It looks basic agreement, it's labeled. So he at some point knew he was supposed to get, his company was supposed to get 20K, and certainly you would agree with me, I'm sure, that when Mr. Ward took possession of the check, at that moment, when he took possession of the unaltered check, he was accepting that check on behalf of the partnership as a partner, not on behalf of himself as a person.
Well, that was a contested fact, Your Honor.
Okay.
I mean, there was a contested
Because he
fact
said
about
he
the
was
nature of that
endorsing it.
transaction.
Okay.
And so I don't want to overstate
I got it. Okay.
the argument.
He was saying he was only endorsing, and it was okay that he was going to take the first 20 because then
And
Rhodes was
then
going to get
Sweeney
some
knew
later.
that. I understand that's a
Okay.
contested fact, and so from a sufficiency standpoint, we're not there. But
Right.
so it's not clear. And in any case,
But it was an agreement between two companies,
Yeah.
not an agreement with him as a person, right? Or you're saying, no, that's contested. He said that a piece of it had a feature of being a personal deal.
of the transaction had a aspect of it that was personal. So
Okay.
so I'm not ready to concede that.
Okay. All right.
But for the purpose of
Be
your
that as it
question,
may.
yeah, it doesn't matter. I don't think, respectfully, that because the question is, how was ACG the partnership? What evidence is there that they actually that one of the partners or somebody on behalf of the partnership was deceived
Or relied.
or relied on
Okay.
this in the transaction? It's not enough for there to have been deceptive actions afterwards that covered up maybe assuming everything in the state's favor, that covered up something, that's not theft by deception.
Well, is it theft? I'm just curious. Is just charged wrong? Typically, an embezzlement kind of scheme involves the victim not knowing about it prior to receiving the funds, and the money is extracted from an account that someone else is entitled to. What is it?
Yeah, whether this could have been charged, and
It just seems
the court
to
will
me
appreciate. I'm not conceding anything.
No, I don't want you to concede.
Could
but
this
it
been
seems to me-
charged as theft by deception of First National Bank? If you believe it, if you take everything in the light most favorable to the state, could there have been deception with regard to First National Bank? It seems like I wouldn't have the same arguments anyway.
No.
And could there have been embezzlement, which would have been obtaining or exerting unauthorized control over property? I think that's sort of the state's argument.
I'm asking questions really not before us, but it just seems to me it's some sort of theft kind of concept here. I'm just not sure deception's the right
I
one.
mean, the state up here argued that the funds never got into ACG's account.
Right.
And that would be some sort of embezzlement maybe, and that's a different subsection of the theft statute. So I don't know if that's possible or not. Moving on to the second issue with regard to making a false information in this case. And I certainly argued this case, and the Court of Appeals decided this case based on this court's ruling in Rios and in Gotti that the crimes of forgery and making a false information are mutually exclusive. If you prove forgery, there's insufficient evidence of making a false information. I have to keep reminding myself now. And so that was the question, and the gray area here is, as my colleague noted, that there have been some of these Court of Appeals cases that have introduced this gray area, and we certainly think Judge Powell got it exactly right to note that these cases, Spencer and Dalkey and Odegbaro, introduced this idea of was this transaction, did it have to do with the defendant's personal affairs, that's not in the statute, and that was not really part of the reasoning of Gotti or Rios, even though those words were used in those decisions. And that if, as Judge Powell did in this case, this court would clarify that the question is, was the document, was it altered in a way that makes it forgery, then it's not making a false information. These cases are very easy and clear, and they had been. I mean, every time I get one of these forgery or making a false information cases, I often have to remind myself and go back and read the cases and say, which is it? Oh yeah, forgery is if I make something that purports to be in somebody else's name, that part of that statute. And if that's the case, it's forgery, and it's not making a false writing or making a false information. So we think Judge Powell got that exactly right in this case, and exactly showed the pedigree of where the error has grown up in these Court of Appeals cases. And in this case, it's, I think, undeniable that if I find a check on the street made out to Chief Justice Nuss, for $1,000, and I put my name on there or Randall, and take it to the bank under the forgery statute, I think that's clear. That's a forgery. I have altered that check to have terms that the maker didn't intend for it to have. It's forgery.
Even if you're right, let's just assume you're right for purposes of argument today. If we think that the way this own affairs, dealing with your own affairs, non-element has kind of been added in, the basic question here still is, did making a false information get proved? So
Putting that aside, where we say it doesn't matter whether they're mutually exclusive, it doesn't matter whether it would also be forgery or it have been forgery, what were the elements of making a false information that were not proved here? Do you agree with me that the state may have a problem on making?
I want to make sure I'm answering your question, Your Honor. So
Okay.
I want to clarify. You're saying if we put aside
Let's
Rios
keep
and
that,
Gotti?
if we can just not focus for the moment on all that's gone before, on differentiating either effectively or ineffectively between forgery and making a false information. And I tend to agree it's been ineffective and a mess.
Well,
But if we put all that aside for the moment, so that you're not relying on that mutual exclusivity to make it insufficient, tell me how it's insufficient.
okay. I will answer your question, Your Honor, but I want to say, but first of all, I mean, this case has been joined, the issues, the Court of Appeals decided this case based on Rios and Gotti and that idea. The state never objected that. The state in their petition didn't suggest that Rios or Gotti should be overruled. So I don't think you should put that aside. But if I do...
You'd like an answer to that no matter
Yeah,
what.
yeah.
I got that. I got that everybody's
yes.
interested in the
So
answer to
then
that.
the answer to your question is yes, I think the state does have a problem. Although, and as I was getting ready for this case, I was sort of wondering, and I have to admit, I didn't particularly alternatively argue that there wasn't that Mr. Ward, there's no evidence that he was a maker. There was evidence in the or notation in the Court of Appeals decision in this case that if he falls under something, making or altering, in a line most favorable to the state, Mr. Ward he altered it. He altered this check. My counsel said in his own handwriting, and so I haven't done research and partially because the issue's never been joined on that part of it of whether I needed to. That wasn't part of the state's response here that he was a maker or wasn't a maker. But I think it would be completely relevant then when we're dealing with a negotiable instrument to look at sort of definitions of what is a maker. And it seems that Mr. Sweeney was the maker of this check. So I do think there are questions about whether if you do reach that issue of whether or not there's any evidence that Mr. Ward was a maker of the document in the first place.
Is making and altering, are those mutually exclusive?
It seems like they should have meaningful definitions so that the legislature is supposed to use words that mean something.
Once you alter a written instrument, it's a new written instrument, right?
I think it could be.
And so, who's the maker of that new written instrument?
Yeah.
The originator of it, or the person who altered it?
Yeah. I mean, when you're dealing with a document like this, at least, it's again, we haven't joined this issue, so it's hard. It's hard because I haven't really looked at that part of that question really hard. But
Well, in the arena of negotiable instruments, typically maker and payor are used interchangeably in some places, and so even if it's altered, if you use that definition, Sweeney would have remained the payor on the instrument.
I mean, it's hard for me to get to a place where I would say Sweeney wasn't a maker on this, wasn't the maker of this check. I mean, even though the line was favorable
Right.
to the state.
He undoubtedly he was originally.
Yeah.
And I guess the question that we are sort of joining now with you is, once that instrument is altered and becomes a brand new instrument, is Sweeney still the maker, or is the alterer the new maker?
And again, I don't have a lot of authority to give to you standing here.
Or a third option, are they jointly the maker? Okay, thanks.
Your Honor, I'm out of time and I don't have anything else.
Any more questions? Thank you, Counsel.
Thank you, Your Honor.
ACG and Mr. Rhodes were under this contract, and when Mr. Ward took these funds that Mr. Rhodes was expecting to appear in the account, he did deceive the partnership through deceiving Mr. Rhodes, who was a member of this partnership. Mr. Rhodes knew he was under the contract, his signature's on the contract. He believed that $20,000 would be forthcoming, and it never was, because it had already been spent. It was already gone, and so he was deceived when Mr. Ward took those funds.
Do you know why it wasn't charged as an embezzlement?
I do not. It would have been.
Does it matter if Mr. Rhodes was deceived?
It does. It does, because Mr. Rhodes was the only other half of ACG Restoration.
But you deceive a partnership if you deceive one of the partners?
Yes.
Okay.
On the forgery versus false information argument, I do think, Justice Breyer, you could essentially set aside most of the analysis of forgery here when deciding this issue, because it does boil down to a sufficiency of the evidence issue. And so, although the definition and element of Mr. Ward being a maker was not thoroughly vetted by either side in either of these briefs, it has always been the state's position that sufficient evidence was presented to prove false information. And in the state's brief, we did walk through how those elements were satisfied. So If the court was so inclined, I do believe as though it could essentially set aside that detailed review of the forgery statute, particularly given now where we are after Rios and Gotti, we're in a position where the two have the same severity level and so on. The court took specific issue in Rios and Gotti with telling the state that the state was not free to elevate forgeries to false informations whenever they so chose, just to get a higher severity level offense. And that was obviously critical in this court's view when it decided Rios and Gotti, because the two were different severity levels. So, false information was a higher severity level. I see I'm out of time. If there are no further questions, I would just ask that this court reverse the Court of Appeals and thus affirm the district court in which Mr. Ward was convicted both of theft and making false information.
Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement